Next thing we need to take a look at are these grounds to have a license denied. There are 29 specific violations of the South Carolina license law that we're getting ready to look at. 29 issues here, things that would be a problem. Now, do you need to try to memorize the 29 violations that we're getting ready to go over? No, they're not going to ask you to list 29 violations. However, should you be familiar enough with these to at least know what's a violation, what you shouldn't do, because that's what they're going to be asking you about. So let's get started. And obviously, what you see on the slides here are just little bullet points. But you can certainly read more depth, more information about each one of these that you'll see in your material. So let's take a look here. Number one, if you make a substantial misrepresentation on an application, that's a license law violation. Obviously, when you finish this course, you're going to have to submit an application to take the exam, and they're going to be asking you some questions, and you better not misrepresent anything in that application. Number two, makes a substantial misrepresentation involving a real estate transaction. In fact, I would probably guess that pretty much all of these are just common sense, quite frankly. But so most of these I'll kind of go through a little bit fast, but some of them I might need to explain a little bit. Number three, if you make a false promise likely to influence, you're just lying to somebody, trying to get them to do or not to do something. Four, if there's a continued and flagrant course of misrepresentation. Now this is one you better be careful of. Is it possible you could provide information to a buyer or a seller that obviously you believed was accurate, but at sometime later you discover it was not accurate? It was absolutely wrong. Should you go back and correct that information? Yes. That's kind of, again, no-brainer. But if you don't go back and correct it, that's what they consider to be a continued and flagrant course of misrepresentation. We talked in an earlier chapter, misrepresentation is not illegal. That's an innocent mistake. But once you discover that you made the mistake, you got to address it. You can't just hope nothing comes out of it or won't be any problems. You got to go back and correct it. Otherwise, that's a flagrant course of misrepresentation. Now you're going to have a problem. Number five, if you demonstrate bad faith, dishonesty, or untrustworthiness in a manner to cause issues to the public, that's going to be a problem. Number six, if you represent a real estate broker other than your broker in charge. We've talked about that. Obviously, if you're not a broker in charge, then you must be licensed under a broker in charge. But the law is very clear. You can never work for more than one broker in charge at a time. Again, if you want to transfer from one to the other, that's fine. But don't be trying to work for more than one at the same time. That's where you'll get yourself in trouble there. 7 is if you guarantee future profits from the resale of real estate. Now, that one's almost laughable. Obviously, you can't be guaranteeing stuff like that. You don't know what the future holds. You can't tell a buyer, they're only asking $200,000 for this house. I guarantee you in 2 years it'll be worth at least $300,000. You don't. From my experience, most agents don't know what the value of property is today, much less what it's going to be worth anytime in the future. That's a no-no. Number 8, making dual sets of contracts. That's a no-no. Probably need to talk about that. I find a lot of people don't understand or know what dual sets of contracts are. But y'all, just to give you an example, once you have a contract to sell that's been ratified, accepted by all parties, then typically the buyer's agent will provide copies of that contract, obviously a copy to the attorney. The lender, assuming financing is involved, is going to want a copy of it. But so basically everybody gets a copy of the contract. Well, it is very common and almost likely that at some point after the contract's ratified, modifications are made. We have amendments, addendums. Probably the most common would be like a repair addendum, for example. The home inspector, home inspector found issues with the property. Seller or buyer asked the seller to make these repairs. Seller agreed to it. So that's an agreed upon addendum where certain work has or issues have been agreed to be repaired. But I will tell you, typically agents do not submit a copy of those addendums or amendments to all parties. For example, the lender. You have to, if anything about that contract changes, you got to submit those changes to all parties. Otherwise that's considered dual sets of contracts. You got the buyer and seller with a different set of agreements now than what, say, the lender has. And I'm just using that as an example. That's considered dual sets of contracts. So you can't just give out the initial contract to sell to all parties and then not submit any addendums that might change the terms. You got to submit it all to, especially to the lender, because, that's what the underwriter is looking for. Otherwise you could be accused of dual sets of contracts, and again, you're going to have a problem there. Number 9, now that's kind of, obviously if you're looking in your book, that particular paragraph is, several lines there. But they identify quite a few examples of state and federal crimes. And if you're ever convicted of any of those crimes, then that's going to be an issue. Now, I'm not considering to go through all those crimes. You can see them there yourself. But at the end of the day, if you're convicted of a crime, any crime, that's probably not going to be, probably not going to go well for you with your real estate license. Because then if you look at number 10, 10 is saying if you are convicted of any state or federal crime, for example, those things in number 9, then now you must notify the real estate commission of such, and it says you must do so obviously by certified mail within 10 days. I'd remember that, by the way. So if you're convicted of a crime, you got to now notify the real estate commission that you have in fact been convicted of a crime. You got to notify them by certified mail and within 10 days. Now, what I want to caution you of here, because I know they like to ask questions about this kind of stuff. Pay attention to the question. If it's talking, a question about, an agent was arrested and taken to jail or whatever. Maybe it states an agent was arrested and put in jail. What should the agent now do? The answer most likely is nothing. Don't confuse getting arrested for something and being convicted of something. So, just because someone is arrested does not mean they're guilty of it. Right? You get your day in court, but once you're convicted, now you got to notify the real estate commission. But if they just indicate that someone was arrested for something, then there's nothing you have to do at that point. So don't let them trick you into saying, well, you got to notify the commission within 10 days. Not if they were just arrested, only if they are convicted of the crime. Number 11, if they fail to account for or to remit any monies. Y'all obviously talking about trust funds. Y'all, we just talked about that in the previous hour. Number 12, if you pay a commission or compensation to an unlicensed individual. Y'all, obviously, that's illegal, as it says. But where you see probably a very common example of this, and it tends to happen, quite frankly, with a lot of new agents, so be careful with this, where people, they'll get their real estate license and then they'll go straight to their social media, Facebook, whatever, put a post out there. All right, friends, I got my real estate license now. Anybody, if you know anybody wanting to buy or sell a house, you send them to me. And if you'll send them to me, I'll give you $500 when it closes. I'm telling you, see stuff like that all the time. Well, whoever you giving that $500 to, or quite frankly, if it was just 5 cents or anything of value, they better have a real estate license. Someone that without a real estate license cannot receive anything of value in exchange for referring business to a real estate agent. That's a no-no. So it'd be illegal on both parties. It's illegal to receive it. It's illegal to provide it. So do not pay commission or compensation to an unlicensed individual. All right, 13, anyone violating the buyer's freedom of choice. It's the buyer's right to choose. That's the law. Well, choose what? Any service provider in connection with a real estate transaction. The buyer gets to choose whoever they want to use. For example, they can choose their own lender. They can choose their agent. They choose the attorney. They choose the home inspector, and so forth. So anyone providing a service in connection with this transaction, they're considered settlement service providers. And by law, it's the buyer's right to choose whoever they want to choose. Well, if you try to tell that buyer that they have to use such and such attorney, because that's who I deal with, that's who I work with the most, that's illegal. You're violating their freedom to choose. Now, let me just throw this out there too, because y'all seem like they've been asking some questions about it. And you see this, quite frankly, is very common with builder, new homes. Well, the builder might tell the buyer, buyer, we have in-house lender and we have an in-house attorney that can do all this for you. And if you would like to use our in-house attorney and or lender, then we'll pay your closing cost. And I hear people say all the time, but Frankie, is that legal for them to do that? Well, yes. There's nothing wrong with offering the buyer an incentive to use a particular provider, as long as it's not stated in such a way that they have no choice, right? You don't have to use it. Now, look, you want to use your own attorney, your own lender, that's fine. You may have to pay for your own closing costs if you do that. The builder saying if you want to use ours, then we'll pay your closing costs. So they're still leaving the choice up to the buyer. So, if they ask you a question about is it okay to offer incentives to the buyer to use a particular service provider, that's fine. Again, as long as it's a choice and not an ultimatum, for example. Anyway, number 14, if you fail to disclose dual agency, we've talked about that in an earlier chapter. But at least in South Carolina, certainly we know dual agency is legal, but only if it's disclosed to all parties up front and all parties agree to it in writing, right? 15, multiple sources of income without the written knowledge or consent of all parties. What they're talking about here is, y'all say, for example, I'm representing a buyer. And in my buyer's agreement, y'all, and again, this is not to suggest how much anybody should charge. Y'all, I'm just trying to give you an example of how something might work here. But say me and my buyer agreed in our buyer representation agreement that I'm going to get paid 3% commission. Y'all, 3% of the sales price will be my commission. And the house the buyer's looking at buying, the listing agent is willing or offering me 3% to sell the house. So in essence, I'm getting that commission from the seller, so the buyer doesn't have to pay for it. But then I also find out that the seller is also offering a $2,000 bonus to the agent that brings a buyer to buy the house. Now, y'all, that's multiple sources of income, y'all, because I'm receiving the commission from the listing agent, and I'm also receiving a bonus from the seller. Y'all, two different parties. That's what this is referring to here. Now, is that illegal? It's not illegal as long as the buyer, y'all, all parties know that, they understand it, and they're okay with it. And y'all, again, that has to be in writing. You'd have to disclose to the buyer, look, not only am I getting 3% from the seller, I'm also getting an additional bonus from the buyer. And buyer, if you're okay with that, please sign here acknowledging that you're okay with it. And if they do, then you're fine. If they don't put it in writing, then obviously that's what they're referring to here, and that would be illegal. And 16, y'all, practicing dual agency without written consent. Y'all, that's pretty much, we kind of touched on that already. But 17, dual agency with an undisclosed principal. Well, what are we talking about here? Y'all, hopefully you recall when we were talking about agency relationships way back. You know, there are different types of principals. You can have an undisclosed principal, you could have a disclosed principal, or you can have a partially disclosed principal, right? You know, undisclosed means if I'm representing a buyer and the buyer chooses to be undisclosed, then when I'm dealing with the seller, I cannot tell the seller who the buyer is, nor can I tell them that I'm representing the buyer, right? But if they choose to be fully disclosed, then obviously now I can disclose who the buyer is and that I'm representing the buyer. Well, part of the requirements for dual agency, part of that disclosure requirement to even practice dual agency, is you must disclose to all parties who the other parties are and what the relationship is between the agent and the parties. You're going to have full disclosure here. So if you have a client that has stated they choose to be undisclosed, then dual agency is not going to be an option. You cannot practice dual agency if you have an undisclosed principal. That's what they're talking about here. 18, the payer acknowledges in writing who will hold the money. They're talking about like the earnest money, trust funds. One of the requirements when you collect someone's money, in this case, earnest money, you got to tell them who's going to be holding the money. The listing agent probably has a trust account. The buyer's agent probably has a trust account. Sometimes you might use an attorney, some third party that has a trust account. So when that licensee collects the money, then you got to tell that client what trust accounts it's going into. Now, it doesn't matter which account. The law just says it must be in a trust account. Doesn't have to be in the buyer's agent trust account. Y'all might put it in a listing agent account or might put it in an attorney's trust account. But the requirement here is just make sure the buyer knows which account it's going into. And again, that's another written disclosure. Must be made in writing. Paragraph 19, if you bounce a check, not going to be a good day. Should not be bouncing checks. Then number 20, if you fail to disclose any material facts, y'all, we know that the law requires you to disclose all known material facts, defects, y'all, stuff like that. 21, if you violate license law, yep, seems like that might get you in trouble. 22, if you violate any order of the commission, yep, pretty sure that'll get you in trouble. 23, gives false information to an investigator, yeah, duh, yep, that'll get you in trouble. 24, engaging in the practice or takes action inconsistent with agency relationship that other real estate licensees have established with their clients. You cannot interfere with another agent's agency relationship. Obviously, what's the first thing, if you have contact with a potential buyer, whether you contacted them or they contacted you about potentially buying a property, what do you think the first thing you need to be asking that buyer? Are you currently working with another agent? If you find out that they have an agency relationship, they've signed an agency agreement with another agent, you got to zip it, turn around, and walk away. You continue talking real estate to another agent's client, that's a license law violation here. Cannot do that. Number 25, if you fail to make records available during an investigation, we know you got to maintain records for 5 years. You better not lose them. Better not have something happen to them. 26, if you fail to submit offers or counter offers, and they're talking about promptly. If a buyer calls you at 10 in the morning and says, all right, we've decided to go ahead and make the offer on the house, please go ahead and submit the offer. And you wait till 3 p.m. to do it. That's not promptly. Because, that's several hours, and, a lot of things can happen during that time. Maybe the seller accepts a different offer during that time because you didn't promptly submit their offer. You're going to have a problem when they turn you in. And then 27, if you fail to provide your current contact information to the commission, we talked about that. We know that if any of your email changes, phone number, address, if any of that changes, for the licensee anyway, you got to notify the commission within 30 days of that change. 28, if you allow an unreasonable delay in closing. And I will tell you where you see this happen a lot typically is when the two agents involved have a dispute over who's going to get how much commission. And a lot of times, just for example, maybe the buyer's agent believes they should be getting 3% commission, but they get to the closing table and find out the listing agent told the attorney that we're only going to pay him 2%. And I will just tell you, when it comes to who the commission breakdown, the attorney is going to take the guidance from the listing agent. That's who they're going to take it from. So if the listing agent says, no, we're only paying 2%, but maybe the listing agent told the buyer's agent 3%, then guess what? You're only going to get the 2%. The attorney's only going to do what the listing agent told them to do. So my point here is, if you start making a fuss, causing issues, and it causes that closing to get delayed, we're just talking about delayed. God forbid if it gets canceled for some reason, because of your stupidity. You're going to lose your license over that. If you do anything or say anything that would cause a delay in closing, you're going to have a problem. That might be the last one you do. And then 29, the last one, if you fail to disclose civil judgments brought on the grounds of fraud, misrepresentation, or deceit. If you have a judgment against you for any of this stuff, it has to be disclosed. And I will tell you, I don't know who's going to want to work with you once they know you've already got a judgment for fraud or misrepresentation or deceit or any of this stuff. None of this is going to, again, it's not going to bode well for you at all. So those are grounds, things that if you get caught doing, y'all will certainly cause you to lose your license. In paragraph B, it does say a little bit of a continuance here. If a licensee must appear before the commission for violations, now the broker in charge must attend the hearing as well. That's somewhat new to the law. If the licensee got in trouble, had to appear before the commission, basically the licensee was on their own. But now the state says, broker in charge, you're coming too. The broker in charge must also attend the hearing and answer questions. Next thing we take a look at is what we're talking about teams here. Real estate teams. And teams have become very common in the real estate industry. Whether it be a 2-person team or a 10-person team. It just means you got multiple licensees that have agreed to work together as a team to conduct their real estate business. And there's nothing wrong with working as a team. Just for example, you might have one member of the team that you handle all the listings or houses for sale. Another member of the team, you work with the buyers. Another of the team, you do all the admin, and so forth. So there'll be all responsibilities will be broke up among individuals to work on the team. And then when a house sells, then the team basically will divide the commission however they decide to divide it up. But that's what we're talking about right here when we say teams. But here's what the law now says about teams. It's the broker in charge that's still responsible for the supervision of teams. And the law is very clear there in paragraph A. It says the broker in charge may not delegate any supervisory responsibility to the team leader. In fact, this is what kind of caused this law to even come into effect, because you would have typically, if you got a team, at least one member of that team is probably considered the team leader, if you will. And a lot of these team leaders have absolutely lost their mind. That's the only way to state it clearly. They've gone nuts. The team leader has no more authority over anybody else on the team than anybody else on the team. Period. That's the law. The team leader does not supervise anybody on the team. Period. So, you may call one of the members as the team leader, but under the law, there's no difference between the person you're considering the team leader and anybody else on that team. They have no more authority than anybody else on that team. And say you got 4 people on the team, just for example. Who do all 4 work for? The broker in charge. So it's not like you got the broker in charge, the team leader, and then the members of the team. No. You all work for the broker in charge. Nobody on the team works for the team leader. I want to make that perfectly clear. That's what the law is saying here. But what a lot of these team leaders have done, they've let in this like an ego trip, I guess. But they're in essence acting as if they're the broker in charge of their team. And that is, the law is very clear. That is not legal for the team leader to act in that type of capacity. The broker in charge is fully and totally responsible for every single person in the office, as well as anybody on teams. So I just want to make sure that's clear. All right. Y'all, paragraph B, y'all here is just saying teams can practice dual agency, if that comes about, but they cannot practice designated agency. So, obviously, if both parties, buyer and seller, are okay with the dual agency all within the same team, that's fine. But if one of them says no to dual agency, but says, I'd be okay with designated, then the broker in charge, whoever they designate to work with that buyer, it cannot be anybody that works on that team. Okay, so designated agency is a no-no with a team. Dual agency is still okay. Paragraph C says we must conduct all real estate business from the office address under the supervision of the broker in charge. Y'all, this is another issue in the industry right now. And I'm not real sure why the commission is not doing anything about it, to be honest with you. But again, y'all, you got some teams that are huge. Y'all, when I say huge, not necessarily in terms of the number of team members. They sell a lot of houses. Y'all, they might be selling millions of dollars a year. Y'all, so they do a lot of business. So what some of these teams have decided to do, because they are so big, I guess, they're doing so much business, they will either rent some commercial space, or in some cases they'll actually go out and purchase some space to conduct all their real estate out of. They just basically move their team into another facility. That's illegal. Paragraph C says all real estate business must be conducted from the same address, like the one that's going to be printed on your license, under the supervision of the broker in charge. You move into another building, there's no supervision there. There's no broker in charge there. So that would be illegal. But I will tell you, you're going to see some teams, they've done it, still doing it. Apparently they're still getting away with it. Then in paragraph D, was talking about advertising. When you're doing any marketing or advertising as a team, you can have, if you got a team name, that's fine. You can put your team name in the ad. But the way that ad is structured, it better be very clear that the team is actually a team working under whatever company the team is licensed for or licensed with. It says the team name may not be more than twice the size of the brokerage name. You got to be, if that ad, if the way that ad is presented, if it would, if a normal person would look at the team name and think that's who's representing me, you got a problem with your ad, because the team is not representing you. It's the company that the team is licensed with, right? So, you're kind of misleading the public to try to suggest that they would be hiring your team. That's a no-no. You cannot do that, okay? So just make sure it's very clear. It might say the Frankie Griffin real estate team of Keller Williams or ERA or Exit or Century 21, whichever it is, it's got to be very clear the team is licensed under whatever the company is. All right. In paragraph E, it says the team name, whatever name you're going to give yourself, must end in the team name or team at ERA or Central 21. That's what we were just talking about there. So I think I already explained that part. And then F, it says if you are going to have a team, then you must register the team with the real estate commission. Again, I think a lot of teams, they just kind of get together and start operating as a team, and they never notify the real estate commission that they're doing this. Now teams have to be registered with the real estate commission. So there's your teams. Y'all, if any of you decide to get your license and join a team, now you know the law. You can go in there and straighten them all out. And then I think the last thing in this chapter that we need to talk about is this stigmatized properties. Well, first of all, what's a stigmatized property? Y'all, stigmatized basically means that something has happened either in the property or maybe around the property that could cause some concern for some people. Some type of concern. It's typically like a psychological issue. Probably one, if not the most common stigma, is if we find out somebody died in the house. That would be an issue for a lot of people. Now, some people would be a problem as long as they're not still there. You've taken them out of there, cleaned up, whatever needs to be done. Then, a lot of people, it's just not an issue for them. But a lot of people it is. It's just it's a psychological thing. They don't want to go in the house, much less live in a house where they know somebody has died there. That's considered a stigma. Now, this is critical to understand what I'm about to say here. First of all, do you have to disclose known stigmas? If you know of a stigma, do you have to disclose that to potential buyers? No, you do not. The only caveat to that is if you are specifically asked a question. If the buyer asks you, Frankie, do you know if anybody died in this house? Now, if they ask me a specific question, then I got to answer it, and I got to answer it truthfully. But if nobody asks me, then I do not have to disclose it. And people, I get it all the time. Well, why not? Why are stigmas not required to be disclosed? Well, do we have to disclose material defects? Any facts about the property? Any issues with the property? Yes, all that kind of stuff you have to disclose. But a stigma is not something that affects the property. The fact that somebody died in a house does not mean anything wrong with the house, right? So there's a big difference there on why you'd have to disclose material facts or defects concerning the property versus what we might consider a stigma. But anyway, so are stigmas required to be disclosed? No, unless you're specifically asked a question. And I said if you're specifically asked. If somebody comes up and say, Frankie, do you know of any stigmas with this property? I am not answering that. Because what's a stigma to me may not be a stigma to you, or vice versa. It's not a fair question, right? So if you don't have a specific question, then I don't have to answer. And not going to. So you want to be careful with that kind of stuff, and hopefully that makes sense. But you see some. We got 4 things here on the slide that might be considered a stigma. Things like owners with a virus or disease. Will tell you not only is that would be a stigma. You could have. There are laws. That'd be considered discrimination. For example, if a buyer asks me, Frank, do you know if the seller has HIV? First of all, I don't know why in the world I would know that, but even if I did know that, that is something I cannot disclose. There are other laws, that because HIV, these viruses and stuff, that's considered a disability. That's discrimination. So for me to disclose, that person's got HIV, that's discrimination. That's illegal. So that's a little bit more than just having a stigma. But death of an occupant or the manner of death, that's a stigma. Off-site condition that's not directly impacting the property, or psychological impact with no material impact on the property. So basically, anything that does not have any impact, direct impact on the property, the house or whatever, then that's just considered a stigma, and there's nothing wrong with the house. Okay? So that's stigma.